On January the 16th of this year, after nearly 30 years, David Tatel retired as a judge on the Circuit Court of Appeals for the District of Columbia. On the cover of his new memoir is a photo of Judge Tatel in his black robe with his dog Vixen standing on his left side. The book is titled Vision, a memoir of blindness and justice. He says that he wrote the book together with his wife Edie. Quote, "Day in and day out, we sat at our long desk overlooking an immense oak tree and the hills beyond. Edie on the left with her laptop, me on the right with my Braille computer. We wrote, we debated, we argued, we laughed, we deleted words, paragraphs, and pages. Slowly but surely, a book emerged." Close quote. One of the things, Judge Tatel, that I read in your book I wanted to ask you about right away is Khalid Sheikh Mohammed. People in this country haven't talked about him for a long time. He's about to have some preliminary trials. And I just wanted you to tell us what your involvement with him was and the importance of it.
Yes. So Khalid Sheikh Mohammed, KSM, to those of us who have been presiding over Guantanamo cases for years, is the alleged ringleader of the 9/11 attacks. He's been confined in Guantanamo for decades. He is also a defendant in a military commission proceeding that is a capital case. In other words, government is seeking the death penalty. My involvement is that most of the Guantanamo detainees, perhaps all of them, have filed over a period of years habeas petitions in the United States District Court for the District of Columbia. That's the district court in Washington.
What's that mean, habeas?
And a habeas petition is one of the oldest writs that the federal courts have, and it is what a prisoner or anyone else confined by the state files in court to challenge his confinement. So it forces the government to justify the confinement of a person, whether it's an arrest or an imprisonment. And the detainees at Guantanamo have filed these petitions as a result of a Supreme Court decision issued maybe 20 years ago or 15 years ago called Boumediene. Boumediene was another detainee challenging his confinement at Guantanamo. And in that case, the Supreme Court ruled that, contrary to the Bush administration's arguments, that detainees were entitled to a fair hearing to challenge their detention. They were entitled to a hearing before a federal court to challenge their detention. So all of the detainees filed those petitions, and the courts for 2 decades now have been hearing and resolving those cases. The other set of proceedings that we've been involved in is that after 9/11, Congress set up a military commission system to try the detainees for the alleged crimes committed on 9/11. These are military commissions, not federal courts. And the military commissions sit in Guantanamo. And they've charged Khalid Sheikh Mohammed, KSM, with capital murder for what happened on 9/11. The military commission proceedings have been very slow and troubled with serious procedural problems. The one you ask about, and the one I talk about in my book, has to do with Khalid Sheikh Mohammed's claim. Let me say one more thing. Decisions of the military commissions, ultimate decisions of the military commissions, are appealable to my court, to the court I used to serve on before I retired, the U.S. Court of Appeals for the D.C. Circuit. And generally, under the law that established them, the detainees have to wait until there's a conviction before they can appeal. But there are certain interim issues, preliminary issues that can be appealed directly to the court, and that's why this case got to my court. Khalid Sheikh Mohammed claimed that the military judge who was presiding over his case should be recused because in various speeches around the country, he had referred to KSM as the ringleader of the 9/11 attacks. In other words, he argued, the judge who is trying me, who is responsible for making a judgment about my guilt or innocence, is already telling the public that he thinks I'm the ringleader. And he filed this petition in the U.S. Court of Appeals, asking us to remove the judge and to vacate all of the decisions that judge had made. And we heard the case on an expedited basis, 3 members of my court. I think, as I recall, it consisted of myself, a Democratic appointee, another Democratic appointee, and a Republican, a judge appointed by a Republican president. We agreed unanimously that the judge could no longer sit, that it violated fundamental principles of due process for a judge to preside over a case where that judge had expressed publicly that he thought the defendant was guilty. And we issued an opinion removing him and vacating all the decisions that judge had made. So that's what the KSM case was.
I asked the case for a number of reasons. One, why in the world has it taken 23 years to deal with this person? That's one question. Another one is, isn't he represented by somebody that the taxpayers are paying for? In other words, I know you say this in your book, that everybody should be entitled to representation by a lawyer. Explain all that, and then we can go from there.
The answer to your first question is complicated. The military commissions have been plagued with procedural problems of just all kinds, Brian. We've had 2 more cases where we've had to remove military judges because of conflicts of interest. There have been serious questions, massive questions, that have been before the military commission for years about what evidence the government is entitled to rely on. Many of these detainees were tortured. The government admits that. And there's a big question about whether and to what extent this evidence can be used, and it's resulted in basically years and years of hearings. The military judges, unlike federal judges who are appointed for life, the military judges are government employees, and they retire, and there have been a series of retirements. So the military commissions have made very little progress. They've been bogged down in procedural difficulties for decades, and to be honest, I don't know when these cases will come to trial. It's a serious problem for the entire military commission system. You ask about the lawyers. This is, to me, a bright side of these cases. There have been quite a few lawyers around the country who, under the auspices of several organizations, the Constitutional Rights Committee in New York, the American Bar Association, and some others, have volunteered to represent the detainees. And I've been hearing cases for 25 years now where the detainees are represented by some of the best, most dedicated lawyers in the country. And to me, this is just as in the 60s, when large numbers of lawyers, many lawyers in the North, traveled to Mississippi and Alabama to represent people involved in the civil rights movement. And just as there are lots of high-quality lawyers who are representing capital defendants in the federal courts, there are a big group of quite dedicated and talented lawyers representing these detainees for no charge. It's pro bono work. It's to me the best of the legal system. it shows that it's just another example of the extent to which lawyers, at least some lawyers in our system, understand their obligation to make the legal system work for everyone, including some of the most, quote, hated, close quote, people in our system.
Jag lawyers.
Where did you grow up?
Jag lawyers.
Yeah. Let me just say one more thing before I go on to that, Brian. Some of these lawyers who have appeared in our court are military lawyers. They work for the government, and the judge advocate system is a extremely impressive system of military justice. And these military lawyers who have represented the defendants mostly in the habeas cases have done just fabulous work. And to me, it's thrilling as a judge to hear a case where you have a really high quality, dedicated military lawyer representing one of these detainees. Again, it's the government resisting, the government's opposing the grant of habeas corpus, but at the same time, it's paying for the lawyer for the detainee. It's the way the system's supposed to work. I grew up in Silver Spring, Maryland. I was born in Washington, D.C., but my parents moved when I was 3 to Silver Spring, Maryland, and that's where I grew up. I went to all through the public schools at Silver Spring.
I should tell our listeners that I think I just heard your wife's voice, Edie. They just should know that she is there and that she can chime in anytime you want her to.
Okay. I told her that, so I'm glad to hear you say that, because as you know from reading this book, this was very much a co-written product. We wrote this book together because it's basically, although it's a lot about the courts and things like that, it's also about our lives together and our marriage. And so we wrote this book together.
How long have you been married?
Almost 60 years. It'll be 59 years this August.
Where did you two meet?
We met, we both went to the University of Michigan, but we didn't know each other there. I was 1 year ahead of her. When I graduated, I went to Chicago for the University of Chicago. And when Edie graduated, she went to Northwestern to get a master's in English. And a friend of ours from Michigan fixed us up. And as they say, the rest is history.
How did you two work this out? Right. And when did you start writing the book?
We started about 3 years ago. In fact, exactly 3 years ago. It was 3 years ago that we made a decision to write the book. It took a while to get going. We needed to write a proposal and see if anybody was interested. But this has been a 3-year project for us.
As you know, I've been trying to get you to talk with us for about 10, 15 years. And what changed your mind on talking? Because we've had you on the network, I think I counted 21 times when you participated in panels and all that. Why is it that you never really wanted to talk about stuff where we're going to be able to talk about today?
As an active judge, I just felt I just felt that being interviewed about my role on the court would be too difficult for me. There was so many questions I wouldn't be able to answer. I wanted to be on your show, Brian, very much, but I felt uncomfortable sitting down for an extensive interview while I was an active judge. Once I took senior status, I'm fairly sure I told Peter that I'm ready to go. Just tell Brian whenever he's ready. But then, of course, we got started in the book. And now that I've written the book, I feel very comfortable talking to you about it, since I've also completely retired from the court. I am now a retired federal judge. And although there isn't anything I've said in this book that I wouldn't have said as a sitting judge, I've been very, very careful about that. I still feel a little freer to talk in sessions like this.
The Peter you referred to as Peter Osnos.
Peter Osnos, yes.
Yeah, we've had him on the network many times and published a lot of our
books.
books.
But of course, you also interviewed one of my most amazing law clerks a few years ago, Tiffany Wright. Yeah.
Let's go to this is the technology in your book. I'm jumping all over the place, but there's so many things that I want to ask you about. I'm going to name these things, and you can tell us what they are and how they worked in your life and when. One is something called iPhone's voice-over function.
Yes.
What is that?
So the iPhone is, for blind people, a magical device. I don't know who at Apple has made this happen, but someone there has decided that the Apple iPhone should be accessible to blind people and to other people with other disabilities. And VoiceOver is the basic technology which reads what's on the screen. And you read it by tapping and by moving your thumb up and down and left and right. And sometimes it's double taps, and sometimes it's triple taps, and sometimes there's double tap, down swipes, and double taps. There's a series of commands you use with your finger, and the phone responds by reading. So you can read a letter or a sentence, whatever, and it's a perfectly clear voice. You can pick the voice you want, and it makes the iPhone completely accessible. And one of the things that's most important to me about it is that VoiceOver and all of the other technology that makes the phone accessible to me is embedded in the phone. In other words, when I buy an iPhone, I don't have to go buy any attachments or any additional devices to make it work. I open it up just like anybody else. I go into settings just like anybody else. The only difference is I go into the accessibility settings and activate VoiceOver, and now the phone is functioning for me. And why I say that's so important is that, it allows me to function with a device exactly the same way a sighted person does. There's no additional cost, there's no additional equipment. It's all embedded in the phone.
You say that Braille and Speak revolutionized your life.
Right.
What is it?
Okay, Braille and Speak is a very rudimentary Braille computer. It goes back to, I would say, maybe the early 80s. And it is when I say rudimentary, maybe a better word is primitive. It's a Braille computer, which means that instead of using keys, which have letters, A, B, C, D, E, you run it, you type it, you run it with 7 Braille keys. And Braille keys are combinations of keys are equivalent to letters. So, for example, imagine, your listeners should imagine 2 columns side by side of 3 dots. In other words, 6 dots. The left column has 3 vertical, the right is 3. It's two side by side. So the top left dot is an A. The top dot and the one below it is a B. The top left dot and the top right dot is a C. That's Braille. It's a combination of dots. And below those 6 dots, there's a horizontal bar, which is the space bar. So after you've typed a word, you then hit the space bar, just like you would on a typewriter, and you type the next word. Well, up until the computer age, I worked with a Braille typewriter that actually typed Braille. In other words, the output was a piece of paper with Braille on it. But the Braille and Speak was one of the first computers that used that did Braille with the digital feedback. And the way it worked was that as I typed, it would speak the word that I had typed. So if I typed, Brian Lamb, after I finished typing Brian, it would say Brian. And then after I finished typing Lamb, it would say Lamb. So I could type this way, and I could make it. I could print it out, either in Braille or on a piece of paper. But the other thing I could do with it, although it was very cumbersome way back then, is with floppy disks. I suspect none of your listeners under 50 know what those are. But with a floppy disk, my secretary could put materials on a floppy disk, and I could download it into the Braille and Speak and read it. And I used the Braille and Speak for a very long time. It was just magical for years, because I could take notes with it. I could keep my to-do list. I could do all kinds of things with it. But primitive is you look back on it today as it's like a Model A Ford. We're much more advanced today. But I used it for 15 years.
When you were on the circuit court, what was a day like?
There were basically two kinds of days. And they were different. Days we heard cases were different from days we didn't hear cases. So on the days we heard cases, and this was a court of appeals, not a district court, not a trial court. We don't have juries. It's an appeals court. It looks just like the Supreme Court. The lawyers for both sides argue before a panel of 3 judges. So my day would begin. So on days we sit, the court would begin at 9:30 in the morning. I would take the metro to the office much earlier. I tried to always arrive by 8:30. I would actually get up very early the morning of sittings and review my notes. After I worked out, after I went to the gym, I would spend a good hour reviewing my notes for the 3. We usually heard 3 cases each day.
Was anybody with you during that time,
No.
or did you go alone?
No, I went alone. At that time, I was using a mobility cane, and although there was some particularly dangerous streets that at one end of the metro, Edie needed to get me across, and at the courthouse end, my clerks needed to. I was pretty good on the metro by myself with my cane.
That's the subway, not the bus.
The subway,
Yeah.
yes, that's the subway in Washington, and I would. It wasn't a very long commute. It took me about 40 minutes door to door. I get to the courthouse about 8:30, and I would usually almost immediately. First thing I do is get a cup of coffee, and I would almost immediately call the law clerk who was working with me on that case, and because I always had a bunch of questions at the last minute. I had been looking at my notes, and I had several questions about the cases we were about to hear. Or sometimes I needed to reread something, and I'd have the clerk come in and read it to me. Then about 9:20, I would walk with the clerk who was on the case that day to the courtroom. My chambers was on the 5th floor, and so was the courtroom, and it was maybe a 2-minute walk down a bunch of very narrow, deserted corridors into and we would enter what we call the robing room. And the robing room is like a lounge, has a bunch of couches, a coffee pot, and all around the walls are wooden lockers where the judges keep their robes. And one of the traditions, and your name is on the locker. So mine said Judge Tatel, but the tradition at the court was that your name stayed there even after you retired. So there were 2 names above mine on this locker. The first name was Judge Edgerton, who had served on the court in the 1930s and 40s and into the early 50s, and was one of the great First Amendment lawyers, judges in the federal system and on the D.C. Circuit. And the next name was Judge R.B. Ginsburg. Justice Ginsburg was on my court before I was. In fact, when President Clinton appointed me he appointed me to fill the seat that was the vacancy that was created by her elevation to the Supreme Court. So I had her name on my. I always loved the fact that my locker had Edgerton and Ginsburg on it, and it always will. And so we would put our robes on, and the other two judges would show up at the same time, and we would chat, sip coffee, usually not talk about the cases. We would usually talk about, depends on who it was, but might talk about last night's baseball game or the weather or clerk hiring or anything other than the case. At 9:30, the court crier would call the case, and the three of us would walk out and sit down, and we would we would hear three or four cases each morning.
Before you go on, I know it changed once you had your dog, but you explained to us how you would find your seat. Give us both both versions.
Yes. So when I had my cane, for many years, for 4 or 5 years, I was the junior judge on the court, which meant that I was the first judge to walk out, because the junior judge sits on the, if you're sitting in the audience looking at the bench, the junior judge sits on the far right. So I was the first one to walk out. Well, what I had done is I had put a piece of tape on the wall right behind my chair. And I could, as I held my cane and walked, I put my finger on the wall. And when my finger got to the piece of tape, I knew I was at my chair. And I turned right and sat down. Worked great. On banks, we probably don't want to go into this at this point, but I'll just say those are cases where the whole court, all 11 of us, sat in a much bigger courtroom. And that didn't work that way. And in that situation, I took the arm of the judge who was in front of me and walked out with that judge. But 99% of the time, I used my piece of tape. And I never missed my chair, Brian. Always got there. I never sat in the wrong chair.
But what happened when your dog Vixen joined you?
Well, when Vixen joined me about 4 years ago, I didn't need a piece of tape anymore at all. My law clerk, who would go to the courtroom ahead of us and would put my computer on the bench in front of me, also put a treat on my chair. And so Vixen and I, by now I wasn't the first judge because I was no longer junior. So my seat might change from court to court, from hearing to hearing. But the clerk put a treat on it. And when Vixen and I walked out, Vixen went right to the treat. And that's where I knew I would sit.
Let's stop for a minute and ask about Vixen. What can you tell us about your dog?
Vixen is a guide dog. She's been with me for almost 4 years now. She's a German Shepherd. She was bred and trained by a program called the Fidelco Guide Dog Foundation in Connecticut. They breed and train only German Shepherds. It takes 2 years to train a guide dog, and a couple of weeks to train me to work with the guide dog. And she's had a remarkable impact. The final chapter of my book is called "The Dog That Changed My Life," and that's not an overstatement. She's actually the dog. I could have called the chapter "The Dog That Changed Our Life," because she changed Edie's life just as much as mine. We both have much more independence than we did before, because there are so many things I can do with Vixen that, I used to depend on Edie for, like, getting across the street to the metro or our long walks in the country. I can now do these myself. And it's just a wonderful, the result of having a highly trained guide dog. It's been wonderfully freeing for Edie. We still go to walks together, but now I can go by myself if Edie would rather garden.
Where is Vixen right now?
Vixen is upstairs lying under the dining room table, having just had breakfast.
What are the
She and I went for a long walk this morning, just Vixen and me. And then after about 45 minutes, we met Edie, and we went to a nearby coffee shop and had a cup of coffee, and Vixen led me back here. So
what did Reuben have to do with all this, and who is Reuben?
Reuben is our grandson from Berkeley, California. And Reuben and his family have a dog they love. They're dog people. And when Reuben was 11, he came to our house in Virginia, and he had brought along a podcast that he wanted me to listen to about guide dogs. And I was captivated by this podcast and realized from the podcast that I was always under the impression that to get a guide dog, you had to go to the training facility to learn to use it. But this program said at the end that for people who were too busy, they would bring the dog to you. And a light bulb went off, and I had been yearning for more physical independence at that time, Brian. I was a good cane traveler, but there was too much planning in my life, logistics, and I wanted to be able to just be free and go places on my own. And so when I realized what guide dogs could do, Edie and I talked about it and decided to explore it. And we found this wonderful program in Connecticut called Fidelco, which always brings the dog to you. Their theory is you're best trained where you live. And so we signed up and took about a year. It's like getting a guide dog is like applying to college. You have to fill out health forms and get recommendations. It's quite intensive. But anyway, it worked for us. And a year later, a wonderful trainer from Fidelco showed up at our apartment, and out of his van hopped this beautiful 2-year-old German Shepherd named Vixen. And she and I have been together 7 days a week, 24 hours a day ever since.
Go back to the courtroom. You're sitting there. You're hearing. You're in an oral argument. What does the sound of someone's voice do to you?
The sound of someone's voice is the same as the sound of that voice to you. It's just that that's the only signal I'm getting. I don't know whether the lawyer's, tall or short, well-dressed or sloppy. I can obviously tell between men and women, but I'm getting the sound. I'm not getting the visuals that you would get if you were sitting next to me.
So does it have an impact on the way you deal with the case, the attitude that the voice has that you're hearing?
It's interesting you ask that question, because I actually have thought about that while writing this book. In fact, while writing this book, I've thought about a lot of things I never thought about before. And someone, it might have been one of my law clerks, actually asked me while she was looking at a draft of a chapter. She said, this law clerk said, is there any way, don't you have an advantage, she said, because you can't see the lawyers? I hadn't really thought about that very much, but in a way I do, because I'm not, there's no way I can be influenced by the subtleties of what people look like. Let me give you an example. Suppose there's a case where, the lawyer on one side is a beautifully dressed lawyer with, a fancy watch and coiffed hair, and the lawyer on the other side is kind of a, unmade bed type of person. It's possible that judges who can see them, I'm not suggesting my colleagues are influenced by this, but bias is subtle, and but bias is a subtle thing. Bias can be deeply implicit, and who knows how people would react to those two different lawyers. I don't, because I can't see that. How important is this? I don't know. I don't think it's very important in the end, because I think most judges are able to filter that out. But it's just one way in which I don't have to. And there are probably other ways. Well, here's one other example. In many of our cases, you have, a single lawyer representing a person in a case against a big corporation. And so on one side of the courtroom, there'll be a half a dozen or a dozen, fancy lawyers dressed to the T. And on the other side is just one lawyer. Well, I'm not going to know that. I'm just hearing these two people argue. And, who knows what a judge, I can imagine a judge having sympathy for the lawyer there all by herself or himself. Not me. I don't know that that's what's going on, unless when we get back to chambers, one of the judges tells me. That's the other thing that's interesting, is that, my blindness kind of became embedded in the DNA of the court. And everybody kind of got used to having a blind colleague. So it wasn't unusual for us to go back to conference afterwards, and one or both of the judges would want to tell me about things they had seen in the courtroom. I always liked that about it. They might come and say, "Hey, David, do you realize that, there were 8 lawyers sitting at counsel table for the defendant, only one?" They would say things like that to me.
How is it that you dream in Technicolor?
I don't know the answer to that. I truly don't. This is another question I was asked. What do I see in my dreams? I still dream in color. I also dream in black and white. Why I dream in color? I was sighted until I was my mid-30s. So I have lots of visual memories. And obviously my brain is full of visual memories, and those memories are in color. So I know what blue looks like, and I know what yellow looks like. So I don't think it's at all surprising that my brain will still record dreams in color.
You say,
but I'm not. I don't really know. Edie has something.
You could describe how you think sometimes in visual terms.
Yeah, and Edie's reminding me that I also talked in the book about thinking. This is another question. Someone asked, "Well, how do you think?" And I think again, I thought about that question of thinking a lot, and because I didn't think about it when I was just doing my work, but as I think about it, I think visually. I picture everything in my mind. It's all there. When someone's describing a picture to me, it forms in my mind, just like one of those things where you fill in the dots, or the numbers, or when someone's describing. And I've been fortunate in my life to live with wonderful describers. My wife is the best ever. My kids and grandchildren are all describers, and as they describe when we're walking along we're walking along dirt road and they're telling me about the mountains, their description creates a picture in my mind. When I'm reading a statute to get ready for a case, I actually picture the statute in a diagram form. Now, maybe you think that way too. I don't know that visual people don't think this way. I'm only describing how I think.
Do lawyers, attorneys standing before you in court, do anything unusual because they know you're blind?
Well, half of them don't know I'm blind. It's totally amazing how many of them have absolutely no idea. Just no idea at all. Those who do, actually, I don't know what they do differently. I think maybe some of them, someone who has no idea I'm blind will just say Section 483. Someone who knows I'm blind might say, Section 483 says, and then they read it. But I actually, don't know the answer to that. You could probably ask one of my colleagues what they think about that question, because they're watching the lawyers in cases where I'm there. But sometimes a lawyer who isn't aware of this will say, well, they'll say to the court, we win under Section 483, and one of the other judges will say, well, counsel, could you please read it? You know, they don't need to have it read it, but they know I'm sitting there next to them, even though I probably already have Section 483 in my notes and can read it myself.
You tell us that in your first decade on the court, that you dissented 38 times, and then on your third decade on the court, you only dissented 12 times. What's that mean?
I think that's, again, that's something I had not noticed until I wrote this book. And when I saw the numbers, I actually wasn't surprised, because I knew I was dissenting less. I just hadn't done the numbers. The reason is that there are basically, I think, two reasons for it. One is, as I gained more experience as a judge, I began to understand that not all disagreements justify dissent. In a routine administrative law case, say about whether an agency's actions are legal, a case that probably doesn't have much precedential value. In my first few years, if I disagreed with the other judges, I'd probably write a dissent. I began to understand after a while that what's the point? The dissent isn't going to, it won't have any impact in the future. This case isn't going to the Supreme Court. It won't change the results of the case. And I began to understand that not only was there no reason to dissent, but it made sense to preserve my dissenting voice for cases where it was really important. And I thought, well, if I dissent less, you know, when I do dissent, maybe the Supreme Court will notice. So it's, you know, like the boy who cried wolf. You know, so that was one reason. The other reason was that as I got more experience, I gained more confidence in my colleagues, and I like to think they gained more confidence in me. And we were able to resolve more disagreements by talking about them. I even went so far in cases to think that, I mean, suppose we had a case where the question was the agency's decision supported by substantial evidence? That's a totally typical case in the DC Circuit. When someone challenges an agency action, we look to see whether the agency's action is supported by substantial evidence. We don't make the decision ourselves. We just say, well, did the agency have substantial evidence to support its decision? Well, after 10 years or so, if I didn't think it did, but the other two colleagues did, I mean, why would I dissent? Maybe they were right. These are subtle questions about whether a record contains, quote, substantial evidence. And if two of my colleagues who I trusted thought it did, gee, maybe they're right. So I wouldn't dissent in a case like that. And I think it worked the other way also. I think that as my colleagues gained more confidence in me, I think when I was on the other side and in the majority, I would hope, I know they would think the same. I know in conference, a judge who wasn't sure would often say, I knew that, I said this often, and other judges said, I said, well, let me wait. If I'm dissenting and not sure, I'd say, well, I'm not sure about the result, but I'm going to wait and see the opinion. And then I'll decide then. And yeah, you can probably persuade me, but I want to see your opinion first. And so those two things were working in tandem. And by the time I got to my last 10 years on the court, I was dissenting very rarely. I went for several years at a time, sometimes without writing a dissent. And I like to think that because of that, when I did dissent, maybe the Supreme Court took notice. Don't know. I don't know that. It's just a thought.
Here's a question. It comes from the book, and I'll spell it for those who don't understand what I'm asking. What is a tittle tot? T-O-T.
Each federal judge and Supreme Court justice gets 4 law clerks. Most of us hire the law clerk for just 1 year. They come right after law school. They start, for me, they start in August and they work until June of the following year. And the clerks all work together. And every couple of years we have a clerk reunion. And my clerks, for whatever reason, started referring to the Tatel clerks as Tatel Tots. And to go beyond that, Brian, you'll have to ask them. But that's what they call themselves.
You have this sentence in your book: if Antonin Scalia had applied to be a clerk in my chambers, I'd have hired him in an instant. I mean, people ought to know, of course, that you were appointed by Clinton, as you said earlier, and that you're not exactly a conservative in most things. So why would you hire Antonin Scalia to be a clerk?
When I interviewed law clerks, I wanted the best, smartest people I could find. And while, no question, heavy majority of the clerks who applied to me were liberals because they viewed me as a liberal judge. I did get applications from lots of conservative judges, and I like to have balance among my law clerks. Law clerks aren't just researchers. I want my law clerks to understand the case and to develop their own views. And most important, I want them to argue with me. I want them to push back and test my own thinking. And it helps to have diversity among our law clerks. It's not good to have clerks who all speak from one side of the political spectrum. I want a clerk who will push back when I take a particular position. That doesn't mean I'm going to agree with the clerk, but I think my own work as a judge was enhanced by having diverse views among my law clerks.
Who decided on the name for the book, Vision?
It came out of, we worked on the book for a very long time. I spoke a lot about vision in the proposal. I struggled a lot with the name. I had a wonderful editor at Little Brown, and he said, just don't worry about it. The name will come to you. And I think it probably came from him or Edie or one of the other people who looked at it. And I wondered about it for a long, long time. It wasn't the only title we considered. But the more I thought about it, the more I thought it was the right title because it had so many different messages. So like the whole book, it just evolved from the discussions with Edie and me and several other people who read drafts and made suggestions, and my editor, Little Brown.
You give credit to Edie for suggesting strongly to you not to have footnotes in your decisions. Why?
Yeah. Edie, my wife, is an English teacher. And she taught writing, and she always told her students that, footnotes are an easy way out. If you want to put something in what you're writing, you should think about where it belongs in what you're writing. I mean, writing isn't just writing. Writing is thinking. And so, to what she taught her students was that, when you stick things in footnotes, it suggests that maybe you haven't totally thought through all this. Well, I thought that made sense. And I did that when I was practicing law. I rarely used footnotes in briefs. And when I did, they were usually just for citations and things like that. But when I got to the court, I said at my portrait hanging ceremony that Edie had just one request for me, and that is that I not use any footnotes. And she had already convinced me of that, but I didn't. And I think it makes for better. And I'm not the only judge who does this. There are lots of judges who don't use footnotes. Speaking only for myself, I think it improves the quality of the opinions because it forced me to think really deeply about what should be in it and what isn't. And so, if if I was tempted to put something in a footnote, maybe it didn't belong in the opinion. And so it would drop out, it would go away. Or maybe I would look at it and say, you know, this is really kind of important. Why do we want the reader to have to look at the bottom of the page to find it? So I put in one of the judges who preceded me on the court, Abner Mikva. He was the chief judge when I was appointed, but at the same time, President Clinton appointed me. He hired Ab Mikva to be White House counsel, so I never sat with Ab. But he never used footnotes, and he used to say, if God had intended man to use footnotes, he would have given us vertical eyes.
Other cases I wanted to ask you about, you write about in your book. One of them is, why did Judith Miller of the New York Times have to go to prison or jail, if you want to call it that, for about, what was it, about 8 months or so? And you were involved.
I think it was about 80 days.
Oh, 80 days. Okay.
Yeah, I think so. Judith Miller was a New York Times reporter. She had written a story that revealed that a particular person, Valerie Plame, I don't think listeners need to know all the details to understand this, was a covert CIA agent. It is illegal under federal law to reveal the name of a covert agent. And the Bush administration, this was a politically sensitive case. The Bush administration was extremely upset about this leak. And they wanted to find out what its source was. A federal grand jury was convened, and it, among other things, subpoenaed the reporter and asked her under oath to say who her source was. The reporter argued, that is the New York Times, that reporters have a First Amendment right not to reveal their sources. And when I got the case, Brian, I was assigned to it randomly. All assignments to cases in the DC Circuit are random. That's what I thought. My first instinct was, wait, how can a grand jury require a reporter to reveal her source? I mean, it seemed to me that can't be right. That, lawyers, I had been practicing law for years, and the attorney-client privilege is a tight privilege. There's a doctor-patient privilege. There's a priest-penitent privilege. There are a lot of important privileges, and I knew a lot of reporters, good investigative reporters, and I knew how important it was to be able to keep their sources secret. Otherwise, no one would talk to them. So I went into that case thinking, this is an easy case. But as happens in many cases for a judge, you realize that the law you have to apply is different than what you think it ought to be. And it was quite clear to me almost immediately that the Supreme Court had already made it crystal clear that reporters do not have a First Amendment right to protect their privileges. Supreme Court ruled that decision was binding on me as a Court of Appeals judge. Now, that doesn't mean that the grand jury can force any reporter to reveal any source. Under the Justice Department's own guidelines, basically they had to exhaust all other remedies, prove they couldn't get the information from any other source, and that it was really essential to the case. And so I ended up, our panel, I was on a panel with 3 judges, we all agreed that under the circumstances of this case, Judith Miller could not protect her source, and we sent it back to the trial court. She refused to reveal the name of the source, and he jailed her for 80 days until the source relieved her of her obligation. Now, there's a second part of this, of my role in this case. Although I agreed, or had to agree, that there was no First Amendment privilege, the other argument that was made in the case was, well, if there's not a First Amendment privilege, there's a common law privilege. The common law are judge-made rules. They're not based in the Constitution like a First Amendment right is. They're judge-made rules or principles to make sure that the judicial system works properly. So, for example, the attorney-client privilege, attorney's obligation not to reveal information he gets from his client. Why have courts adopted that privilege? Because unless a lawyer can keep confidence in the information he gets from his client, the client won't disclose fully, and the lawyer won't be able to represent that person adequately. Lawyers have to have all the information from the client they need to represent the client fully, including whether the client's guilty. And so there are lots of judge-made privileges. And I thought, looking at history and practice, that there should be a common law reporter source privilege. And other courts had so ruled. There were many state courts that had adopted a common law reporter source privilege. And I wrote a separate opinion in the case arguing that the federal court should adopt a common law reporter source privilege. But then I went ahead and said that a common law privilege would not be absolute, it would be qualified, and that even if there were a common law privilege, I thought that Miller would still have to reveal her source in this particular case. So I didn't dissent, I concurred, and I wrote the opinion because I was hoping that it would help shape the views about this really important issue, and maybe encourage Congress to pass a qualified reporter source privilege, which it hasn't done.
For those that have never been here, your office, 5th floor of the building at about 3rd and Pennsylvania Avenue, and on some of the other floors, the district court judges sit in trials. And then yes. I think it's the 3rd floor where the grand jury might meet. The reason I'll tell you a little bit more why I'm asking you this. Then you can look out the window of the cafeteria or maybe your office and see the Capitol, and then right behind that is the Supreme Court.
Yes.
A lot of power right now. We've been going through this for the last couple of years. Sit right there, about 2 or 3 blocks apart. Is there too much power in that situation?
You mean in the Supreme Court?
No, just all of that. I mean, a lot of very, very significant national decisions are made in that 2 or 3 block area.
Yes, in between the Congress, the Supreme Court, and the U.S. courthouse. No, I don't think it's too much power. I think the important question we have to ask as citizens is, how is that power asserted, exercised? Is it exercised properly? Is Congress functioning and performing its legislative duties? Are the courts acting as courts and not intruding into the other branches of government? I think that's the question we need to ask. Not whether there's too much power, but is it being used properly?
And is it?
Well, I have some doubts about it. I worry. I worry that this Supreme Court, and I want to say what I'm about to say, Brian, comes from my experience serving for 30 years on the U.S. Court of Appeals. These are my conclusions based on that experience and my experience being reviewed by the Supreme Court. I've tried very hard to focus my book on what I know best. And that's basically, the voting rights cases and the environmental cases. Those are the ones I know best. My concern is that over the past decade or so, the Supreme Court of the United States has failed to honor the principles of judicial restraint that are so important to protecting the checks and balances of government, and that its decisions have slowly but quite clearly strengthened the power of the courts at the expense of the other two branches of government. And that's dangerous because the courts are unelected. If the courts issue opinions that the public doesn't like for some reason, they can't vote against it. Judges don't run for election. They can vote against congressmen or senators who support legislation they don't like, but that's not so for the courts. So it's critical to the checks and balances of our government. It's maintaining the proper balance between the three branches, that the courts confine themselves to the judicial function and not intrude into the functions of Congress. And my worry is that this Supreme Court is doing that all too often.
Before I give your time back to you, tell us about this experience of having a dog. And, you know, you explained earlier how you use the dog, but not to any great extent. What else does the dog do for you on a day-to-day basis that we can't know unless we had a guide dog?
Before I answer that, I want 2 sentences of background. Vixen has been with me for 4 years. I've been married to Edie for almost 60. Vixen's a relative late comer in our family, a wonderful late comer. But the fact is that, you know, to the extent I've been successful as a blind person, Brian, it's mostly due to my wife and Edie's and our wonderful marriage and our children and a very supportive family. And so I don't want to overemphasize Vixen's role in here. In fact, you know, the chapter could have been called "The Woman Who Changed My Life," or more accurately, "The Dog That Changed Our Lives." But people are interested in dogs, and "The Dog That Changed My Life" made sense to Edie and me because she knows how much things have changed with Vixen. And I mentioned it before. It's all, well, there's 2 aspects of it. One is, well, the first part is I've just fallen totally in love with my dog. I never, and this isn't because I have a guide dog, it's because I have a dog. And I think the world would be better off if everybody had dogs. I think dogs are a wonderful contribution to humanity, and it's too bad we don't have more of them. But that's true of all dogs. But Vixen, again, to say what I said earlier, the most important thing Vixen does for me is independence. There are so many things that I can't do because I'm blind, that I want to do as much as I can by myself. It's like, you mentioned the Braille and Speak. You didn't go into my other technologies. There's so many. It used to be that I had to have everything read to me. Newspapers, magazines, books. I can read them all myself now. It's that independence. It's so important to the life. I'll speak about myself as a blind person, but I know it's true of everybody. Vixen has contributed enormously to that independence. How does she do it? She's extraordinarily well trained. She knows her lefts from her rights with both words and hand signals. We communicate in many very subtle ways. We communicate through the handle of the harness, which I can feel, through the leash, through the turning of her head. When guide dogs are trained not to relieve themselves in their harness, when we're walking along and Vixen needs a break, I feel a big lick on my right hand. Or I can tell by how she's looking to the left that she would like to have a stop. She communicates with me in so many subtle ways. In fact, you know, we've been together for 4 years, but I still learn new ways in which she's communicating with me. And I communicate with her in many ways, with my voice, with my hands. Sometimes, with just a command. And she's amazing. Guide dogs are so intuitive. Vixen's a problem solver. If we're walking down the street and say there's a car in a driveway crossing the sidewalk, Vixen will stop, and I can sense her head looking left and right, thinking about which way to go. And she'll make a decision and take me around the car. If we're near a construction site and there's a pedestrian passage you have to go through, Vixen will figure it out. When Vixen relieves herself, she takes me to the trash can. She's an amazing animal.
She lets you be alone.
And Edie just reminded me one of the most important things, which is important to writing this book. A few years ago, Edie and I were both interviewed about the guide dog, and Edie said something that I hadn't thought about, which is Vixen allows David to be alone. When you're blind and you're never alone, I can go out with my cane most of the time, but I'm still, sometimes asking for help. When you're going for a walk, you're not alone. And until she said that, I hadn't really thought about it. And for the past 3 years, I've been able to go on 5, 6, 7 mile walks with Vixen all by myself. And the aloneness, when you're walking with someone, even if your wife, you want to talk, you're not alone. It's wonderful. It's just different from being alone. When you're using a cane, you're constantly thinking about the cane. Where is it going? Listening to the taps, making sure you're not running. I don't have to think about any of that with Vixen. She's in charge of that. So she frees my mind to think. And so I have no doubt, Brian, that, I think I said at the beginning of this book that, of our discussion here, that this book, when Edie and I started this, we thought we would just write down our story, but it turned out that it was far more complex than that, and that we spent a lot of time thinking about issues that we hadn't thought about how the guide dog, how blindness has affected our marriage and our children. And I thought a lot about my views about the court that I hadn't thought about before. A lot of that thinking was done on walks with Vixen. I'd come back from a long walk and I'd say, "Hey, Edie, what do you think about this?" Or I'd sit down and write down some notes, And so Vixen has freed me to have that wonderful human pleasure of being alone. I say in the book that when I'm walking along Long Mountain Road, that's our favorite hike in Rappahannock County where we live. When I'm walking along a Rappahannock Road with Vixen leading me, and I'm listening to the birds and the stream, I can forget that I'm blind. It's quite extraordinary.
The title of the book is Vision, a memoir of blindness and justice, and our guest has been retired Circuit Court Judge David S. Tatel. Thank you so much for your time.
Thank you, Brian. I've enjoyed our conversation.
Thanks for listening to the BookNotes Plus podcast. Please rate and review BookNotes Plus, and don't forget to follow so you never miss an episode. Questions or comments, we would love to hear from you. You can email us at podcasts@c-span.org.